Probation is an important aspect of managing the offender. It keeps him on the hook since the sentence is just dangling before him. Probation is the key to a court being able to do something about recidivism.
In Nevada, driving under the influence is a serious offense. Nevertheless, your punishments following a DUI conviction may vary depending on the circumstances. The judge may fine you, remand you to community service, sentence you to jail, or choose another disciplinary method. He could also put you on DUI probation.
Only those convicted of a first or second offense within 7 years are eligible to receive the sentence of DUI probation in Nevada. It does not necessarily replace a jail sentence, but those who meet its requirements can benefit from lowering other penalties.
The court that imposes a DUI probation intends for it to function as a punishment and a means of rehabilitation. In Nevada, its terms will typically include such things as random drug testing, substance abuse counseling, community service, vehicle restrictions, mandatory DUI school and victim impact panel attendance, meetings with an assigned probation officer, regular appearances in court, close supervision, electronic monitoring through an interlock device.
Whichever requirements apply in your case, you must meet and comply with them. Any failure to do so will only compound an already serious situation.
What happens if you violate the terms of your probation? The judge who has sentenced you to DUI probation has done you a favor, saving you from a fate that most consider far more severe. In return, the court expects you to stick religiously to its conditions. Any failure to do so will engender additional punishments that could include the reinstatement of any suspended penalties, the imposition of additional fines or fees, incarceration. Many judges respond to DUI probation violations by imposing the maximum sentences permissible up to the law's limit.
The probation officer who finds that you have violated one or more terms of your probation will respond by filing a report. The court, in most cases, will then schedule you for a probation revocation hearing, at which you can attempt to defend your actions. Although the probation revocation hearing is similar to a standard bench trial, there will be no jury. There will, however, be a judge before whom you must appear. You can submit evidence, cross-examine witnesses, and testify on your behalf. You will also have the right to avail yourself of legal representation. Unfortunately, that is where the similarities end. At a probation revocation hearing, the prosecutor does not need to prove your violation beyond a reasonable doubt. A preponderance of evidence alone will do the trick. That makes these hearings harder to win than would be the case with a standard court trial. If you hope to emerge victorious, you will require the assistance of a good criminal defense lawyer. If your legal defense fails to gain an overturn of your probation revocation, the penalties you face will be severe. When will the probation revocation hearing take place? Once it is scheduled your probation revocation hearing, the courts will notify you in writing of the date, the time, and the place. This should occur within a reasonable period following your violation. Unfortunately, if this violation involved the commission of a crime, your revocation hearing will likely take a back seat to the legal disposition of your criminal offense.